dark jacket walking around the building with the hood on.
Yeah.
And I was like, who is that?
Oh, Will?
It was Will.
He's just like,
That was,
You're like, oh, another homeless.
I know, that's what I thought, oh my God. And I didn't see a car and I had okay.
oh, I don't remember. I had that same experience this morning. We were driving like these two old dudes. As soon as they heard me talking, they put the hood on. And then before that, this dude was with his dog looking for someone. Beforehand. We put two and two together. And just looked at them the whole time so they could see him.
So they-
Except they were just actually normal residents because they were walking with the other residents. And like, oh god, this is embarrassing.
I know.
Like such a dick.
You can't trust anybody now. I was gonna call the police on Will. Take him down, take him down.
Fence. Not criminal fencing. It was a good also enjoyed it.
Does anybody have the sign-in sheet? So, do you have a sign-in sheet?
It's back here.
Okay. Whatever. Anybody here from,
Yes, Trish said she was stuck in traffic, but she was gonna try and get there in a few minutes. That's online.
okay. Hey, Clara, you don't have to do a case today.
Yay.
Well, there's only 4.
Oh.
Unless Trish doesn't show up.
Okay. Okay.
Okay.
Alright.
So, we turn to motions for summary judgment, also known in the business as MSJ or MSJs. So, we've gone through the pleading stage. There's been discovery. Almost always, a motion for summary judgment is filed after discovery has been complete. Because one of the ways to beat a motion for summary judgment is to include in your opposition that discovery is not complete and that based on the moving papers, it appears that there is at least one witness or additional discovery that needs to be completed before you can complete your opposition. And a judge will almost always grant that motion unless it appears that the opposition is not after any evidence that would indicate that there is or is not a disputed issue of fact. Okay? You understand that? Okay, but so it's almost folly to file a motion for summary judgment until you've completed discovery. Okay? On a motion for summary judgment, the moving party must demonstrate that there is no genuine dispute as to any material fact. You guys need to memorize this phrase. Because this will be on your essay questions from here on out. Almost every essay includes a motion for summary judgment. Okay? Up till now, you have motions to dismiss and stuff. But now it'll probably be a motion for summary judgment, and you have to recite what a motion for summary judgment is. In order to be granted, you must the moving party must demonstrate that there's no genuine dispute to any material fact. Another way of saying that, but you're not going to say that because those are the words of the rule. And you have to state the words of the rule. That's pretty easy, right? Mm-hmm. So you just memorize that. What is it? 7 words. Okay? But another way of thinking about it is that a summary judgment motion would be denied if there is a genuine dispute as to even one material fact. Okay? So most motions for summary judgment are filed by the defense. It's very unusual for a plaintiff to file a motion for summary judgment. If a plaintiff makes a motion for summary judgment and there are defenses, then they're gonna lose. All the defense has to show, right, is that there's a dispute as to whatever the plaintiff states, and the dispute relates to one of its defenses. That's a dispute as to a material fact. Okay? So you almost never see a motion for summary judgment from the plaintiff. They're always from the defense. Of motions for summary judgment, at best, 50% are granted. Okay? They're very expensive. It's not unusual to see them, how much you think they would cost. What do you think? You see some of this stuff.
Well, I feel like there's a lot of factors that go into it.
Yeah, but I'm just talking about generically, what would you expect a motion for summary judgment to cost?
50,000 maybe?
That's all. Look at her face. Yeah, they're very complicated. They're highly attorney hourly intensive. Okay, and in a minute we'll go over why. But just as an example, from the judge's standpoint, I may have mentioned this, that I was hired to review an attorney's billings for motion for attorney's fees recently. And I thought that his attorney's fees were way out of line. Because in that case, I'm not giving anything away because I'm not telling you who it is or what it's about. But in that case, one deposition was taken and there was a motion for summary judgment. And the plaintiff filed interrogatories and took the one deposition. But other than that, nothing was done. The defense never filed anything. They didn't file any discovery. They didn't take any depositions. Okay? So other than that, you just have routine court appearances. And the attorney's fees were $300,000. That's too much. I mean, that's just ridiculous. There's no way you can justify $300,000 for one deposition, a tiny bit of discovery, and a motion for summary judgment. Okay, and it was a collections case. So basically, you're just talking about breach of contract and what's owed. So after I went over it, I reduced it to like $125,000, which to me is about right for that kind of case. That's on the high side, but you know, you can expect the judge will probably reduce it anyway. So I'm comfortable saying $125,000. So they made a court appearance earlier this week, and the opposing counsel argued that the attorney's fee should be $50,000 because that's what his attorney's fees were. Why are you chuckling?
Not a really good argument.
It's not. It's like, okay, that, you know, they asked he didn't state what his billing rate was, how many hours he put into it, what his training background and experience is. You got to be able to know that information to compare one firm's fees to the other. Okay, so at any rate, the judge said, "Wait a minute, $50,000, that seems kind of low. There was a motion for summary judgment." So the judge is assuming the motion for summary judgment, I think alone is probably 50. All right? That's just off the top of the judge's head. Okay? So it's not unusual these days to see a motion for summary judgment at $50,000. And in a personal injury case, it's the dreaded motion for summary judgment because the attorneys in a personal injury case are doing it
Contingency.
on a contingency. They're not getting paid. All right, so they may have to do $50,000 worth of work and they're not getting paid for it. And if the defense wins, they're out of court. So when you get a motion for summary judgment in and you're on the plaintiff side, you know, red lights are going off. All right, this is a very important motion. It's probably in civil litigation, it's probably the most important motion that can be filed because it results in the termination of the case if granted. Okay. Sometimes if the defense has a lot of money and they just want to engage in it for the purposes of additional discovery, they'll approve of a motion for summary judgment, knowing that it's more likely than not that they'll lose, but in order for the plaintiff to beat it, they're gonna have to reveal something that the defense doesn't think that they've revealed as yet. Okay, it's basically lay all your cards on the table motion. Okay, so occasionally you'll see that, but most of the time, no defendant is gonna spend $50,000 in the hopes that they might get some additional discovery. The time to file a motion for summary judgment, a party may file a motion for summary judgment anytime until 30 days after close of all discovery. So the rules envision that most parties are going to wait until discovery is over. And then they want the parties to file the motion within 30 days of the close of discovery. Now, discovery closes because the court in federal court at the early meeting of counsel and that early conference sets dates, and one of the dates that it sets is when discovery will terminate. All right? And most federal courts will stick with that date. More often than not, if counsel files a motion to extend it, they won't, because it's usually set pretty far out, like 6-8 months from the date of the early meeting of counsel. So remember that 30 days from, it's up to 30 days after the close of discovery. That's something that you'll probably see on a multiple choice question. You know, the time limits are usually multiple choice questions. They're usually not part of DSA. Could be, but highly unlikely. I usually don't throw that stuff in. I'm not really interested in it. So unless you see something in the facts that has dates, you know, like the cutoff date is such and such a date and the motion was filed on such and such a date, which you can assume there's probably an issue there. But if you don't see that in the question, don't bother saying they can file it anytime up to 30 days after close of discovery, because you're just expending additional effort for no points. A motion for summary judgment can be for the whole case or for partial summary judgment. Okay, partial summary judgment usually is to get rid of one or more claims when there are multiple claims. Okay, if you can say there's 5 claims and you can get rid of 3, and you're down to 2. That's better for the defense than defending on all 5 claims. But a motion for partial summary judgment, which is called summary adjudication, because it doesn't get rid of the case. Summary judgment results in a judgment. The case is terminated and it's a judgment against the opposing party, okay? And it's a final judgment. So that's a motion for summary judgment. If it's partial, it's summary adjudication. What's adjudication? It means that a judge has made decisions, okay? But it's only partial. Part of the case is going to remain. So if it's a partial, if the motion is for partial adjudication, you got to call it partial adjudication, not summary judgment, okay? The motion for summary judgment or partial adjudication may be supported or opposed with affidavits and declarations. You don't call witnesses for the motion. Deposition, you attach portions of the deposition, not the entire deposition. And you have to, in your opposition, you have to state the page and line numbers of the testimony that you're relying on. That takes a lot of time. It doesn't sound like it right now, but if, say there's like 10 witnesses and there's a bunch of testimony, you got to pour through all these transcripts and you got to lay out all the testimony in separate sentences for each fact that you're relying on. And that fact may include declarations of some witnesses because it didn't come up in depositions or in discovery, portions of depositions, answers to interrogatories, documents that have been filed in the case and exchanged, and every one of these, the pieces of evidence that you refer to, whether it's a declaration, portions of depositions, answers to interrogatories, whatever, has to be attached. So then you have to refer to exhibit 1, 2, 3, 4, all the way down the line, okay? It takes a lot of time. You're also burning a lot of money on copy fees. And you can attach, and you can rely on any other material that's in the record. What's the record? It would be filings, pleadings. It could be in an answer. If there's something in an answer that you deem to be an admission, you can refer to that. Okay? The issue on any motion for summary judgment question is very simple. Is there a genuine dispute as to any material fact? So what are you going to look for?
Facts that are at issue.
Excuse me?
Facts that are at issue.
Well, first you got to look at what are the facts, right? And then you got to look to see whether or not there's a dispute to those facts. If there's no dispute, okay, yes.
So the dispute meaning is there's 2 sides of the story is what does dispute, right? Say one said this and one said that.
You know, we're going to go through it in examples in these cases, okay? But yes, right. If both sides say the same thing, then there's no dispute, okay?
But they don't have to formally stipulate to it.
No, it can be in all of these documents that we've just referred to.
Yeah.
Okay, all this evidence is just referred to, and in order for you to demonstrate that there's no dispute, you can't just say there's no dispute in your moving papers. The plaintiff can't just say, or I'm sorry, the defendant can't just say, there's no dispute as to any material fact regarding liability. Okay, you have to say, you have to lay out all the facts in the case, right? Make it simple. It's an auto v auto case, and it's a rear end. So you have to demonstrate, number one, if this is a rear end auto accident, you can refer to the plaintiff's complaint. The plaintiff's complaint states it's a rear end auto accident. And then you can also refer to plaintiff's deposition where she says that I was sitting in my car, traffic was stopped, and this guy rear-ended me. And that's the guy, okay? But the defendant is disputing, what can you dispute on a rear-end auto accident? The plaintiff was not sitting still, okay? And so, although my bumper touched her, there was no damage, and she said she wasn't hurt. And he puts all these facts in his motion for summary judgment. What's the problem with that?
She has no damages? She has no damages?
No, the identity is, he's admitted to identity. He says that she wasn't stopped, she was moving. So he's admitted that he's the guy that hit her. But he's saying, I didn't hit her, I just touched her. Okay, should that motion be granted or denied?
Denied,
Why?
because there's a material issue that's at fact, whether or not she's saying that he rear-ended her and he's saying that he just touched the bumper.
She's saying that she was sitting still, and he's saying she was moving. That's a disputed fact, right? That's a bad motion for summary judgment. Okay? It has to be undisputed. If it's undisputed, then the court can determine whether or not that fact would constitute terminating the case or not. But it has to, it has to be disputed. Now, all the plaintiff has to do to win that motion is say, hey, right there, the guy just conceded that there's a disputed issue of fact. Denied. That's how motion for summary judgment in opposition goes down. Okay? But that's what you have to be looking for in the question. There's going to be no question that there's a motion for summary judgment, because the question will say, defendant filed a motion for summary judgment, how should the court rule? So then you got to start out with that. And you can refer to it as MSJ. You don't have to write motion for summary judgment all over the place. You start out by saying motion for summary judgment, and you go parens MSJ, and thereafter you just refer to it as MSJ. Everybody in the business knows what an MSJ is, and nobody says motion for summary judgment. Takes too much time. Okay? So, what are the issues? Is there a genuine dispute as to any material fact? As part of the court considering a motion for summary judgment, there's two sub rules that that the court has to follow, and you have to include it in your answer to what a motion for summary judgment is, and that is the court does not weigh the evidence, and the court does not determine the credibility of evidence. So when you're describing a motion for summary judgment, first you say the court, in order for a court to grant a motion for summary judgment, it has to determine that there's no genuine dispute as to any material fact. And then you go on to say the court does not weigh the evidence, and the court does not determine the credibility of the evidence. What do we mean by weighing the evidence? We mean the court does not determine whether one side's evidence is better than the other. Okay? Weighing the evidence means giving more weight to one side than the other. The court doesn't do that. It takes both sides' evidence as having the same weight. Okay? So even if the plaintiff's evidence seems to be a bit far-fetched, if it's possible, then the court can't say, well, I think that the defense's evidence is more credible, more believable or better than the plaintiff's. Both sides have to be considered equal. What do we mean by the court does not determine the credibility of evidence? What does credibility mean? Anybody?
Whether or not it's truthful.
Yeah. If somebody's a credible witness, what does that mean?
They're
They're being
believable.
honest.
They're
Believable. Yeah, they're a good witness. They're believable. Court doesn't do that in a motion for summary judgment. Okay? It takes whatever the testimony is at face value. So, knowing that, let's look at an example of a motion for summary judgment in Tolan versus Cotton on page 589, Brian. Remember, the rule of the case is not Rule 56. We want to know how the court interprets that rule. Okay? We know what a motion for summary judgment is.
Right.
There has to be no genuine dispute as to any material fact. So what does the court do with that in this case? Right?
Tolan versus Cotton, 2014 case. Facts are pretty long, so I'll try to get through it quick. Petitioner here is Tolan and his cousin were driving a black Nissan SUV and quickly turned into a residential street and parked in front of the home. They were noticed by John Edwards, an officer on patrol in the area, and he attempted to obtain information about the vehicle and the computer in his car, but keyed in information correctly. So he instead got the license plate of a stolen vehicle.
Slow down.
So he quickly drew his service pistol and ordered Tolan and Cooper, his cousin, to the ground and ignored Tolan and Cooper's explanation that it was not stolen but belonged to Tolan. So shortly thereafter, Sergeant Jeffrey Cotton arrived on the scene and drew his pistol and reacted the same way to Tolan's mother's and father's explanations.
What?
Yeah, he ignored them saying that the house and the car belonged to them,
By whom?
but
The parents.
the parents, yes.
Okay.
So
So the parents were outside
they came.
and the parents were saying, hey, that's our car.
Yeah, one of them.
Right?
And so the following events were disputed by both parties. Tolan's mother and Cooper testified that Cotton grabbed Tolan's mother's arm and slammed her against the garage door with such force that she fell to the ground. Cotton testified that she flipped her arms in the air and told him to get off her as he was escorting her to the garage. Also, it was disputed by both parties whether Tolan rose to his knees or his feet upon witnessing the treatment of his mother. That is, treatment his mother received at the hands of Cotton. However, the parties agreed that Tolan exclaimed from 15 to 20 feet away to get your effing hands off my mom, and Cotton responded by firing 3 shots at him. Tolan sustained a bullet wound to his chest, collapsing his right lung and piercing his liver. However, he survived. However, he suffered a life-altering injury causing him to experience pain on a daily basis.
Okay. Was there anything else in dispute?
Okay, so the portion where,
What's in dispute?
Whether he was on his knees or on his feet.
well, he rushed after him or ready to charge,
What?
whether he was ready to charge at him.
What are all the facts in dispute?
Oh, these ones I just mentioned.
Why don't you read them again?
Okay.
Slowly.
So the facts of dispute were the following. So Tone's mother and Cooper testified that Con grabbed Tone's mother's arm and slammed her against the the garage.
Whether the cop did that.
Whether or if he escorted her and that she was being
Of course, yes.
Well,
So
disobedient.
whether the cop used excessive force on the mother or not, the cop said, of course not, I was just escorting her.
Okay.
What else was in dispute?
The second one was whether Tone rose to his knees, but not showing his readiness to charge at him, or if he actually rose to his feet and was ready
Was in
in attack mode.
an aggressive crouch.
Mhm.
What else was in dispute?
And wasn't it? Those were the main ones I think I wrote. I'm not sure if I missed.
How about the lighting on the porch?
Oh, I meant to get in that later. Yeah. So is
No, that was in dispute.
Yeah. So
How about whether or not the kid who got shot shouted words that were an overt threat?
they said they agreed on that saying. He said, "Get your effing hands off my mom." That's what they said they agreed on.
Those words were an overt threat? Get your fucking hands off my mother is an overt threat?
No, so they agreed on that portion of when he.
That he said that?
Yeah. But
Okay.
I guess the disagreement is the perception of like whether it was him getting ready to attack. I think that's what I'm saying.
Yeah.
And then of course the dimly lit porch. Apparently there was a floodlight.
The plaintiffs say there was a floodlight and the cops say it was dark.
And I think he said it was decorational regards to the light on the porch.
What?
He said it was described as decorational instead of more like.
Yeah, it wasn't well lit.
Right.
So it was dark, see?
Mhm.
The cops want it dark
So he
so that it becomes more,
fearful for his
yeah,
life.
they become more fearful because they can't see well.
Right.
Okay? They can't see that this guy's really on his knees and it's just,
Screaming for his mom.
and he's, yeah. Oh. No, it's just a 10-minute. Why do I do this?
Okay, so 30% away.
No. They paid for last weekend. Huh? It was a weekend from hell. I'll explain in a minute. Yeah, okay, so we've got those two, we've got differing versions of what happened,
Yes.
okay? So they filed a motion for summary judgment,
Mhm.
right? What did the district court do?
Yeah, the district court granted that and the court of appeals affirmed his reasoning
That they were using self-defense.
that they were.
But
Yes,
they,
it doesn't
yeah,
list
they
it.
were in reasonable fear for their lives, therefore they could shoot the kid. Okay? And the Court of Appeals, the circuit court affirmed.
Yes,
So this thing wound up in the Supreme Court,
correct.
all right? By the way, in the day, this was 2014, that's not the day. This is not unusual that district courts and courts of appeal will take the side of the cops. Okay?
Mhm.
Why do you look at me like?
I was just wondering why, especially now when, even 2014, it was such a big hot item, to, everybody was running.
Depends on who the judges are, doesn't it?
but you would think they were looked at, because the media was covering everything, so you really had to look at all the facts, as a judge, so.
I'm just telling you, facts of life is as often as not, a court will side with the version given by the police and not the plaintiff in a civil rights case. Okay? Which is why you want a jury trial. Okay? In most civil rights cases, you want a jury trial. You don't want a judge deciding the case. So, what's the issue?
Okay, so the issue then is, may summary judgment be granted when the evidence viewed in the light most favorable to the non-movement established that the movement is entitled to judgment as a matter of law.
What?
So
Say that again.
it says,
Say that again.
Can summary judgment be granted when the evidence viewed in the light most favorable to the non-moving party establishes that the moving party is entitled to judgment as a matter of law?
That's not right.
Okay, I just flipped around the rule, I thought it was on page
Read
5.
that again slowly.
Okay,
There's one thing that you got wrong.
so can summary judgment be granted when the evidence viewed in the light most favorable to the non-moving party establishes that the moving party is entitled to judgment as a matter of law?
That is correct.
Okay.
Okay,
Yeah, I just flipped around.
But-
the rule on page
but-
5.
but how does that relate to this case?
Well, the court sided with the non-moving party only, based on the facts given by Cotton, and it's those facts were not in most favorable to the to non-moving party, which is only.
What did the court do in this case?
They weighed evidence much greater for Tolan or Cotton instead of the evidence here.
Yeah, so that what you're saying as the issue isn't the issue.
Okay.
The issue is in ruling on a motion for summary judgment where there are genuine issues of disputed fact,
Uh-huh.
because that's what you have here. You got genuine issues of disputed fact on the lighting, on whether or not they threw the mother up against the garage door.
Yeah.
It was a garage door, right?
Garage door.
Yeah. And whether or not the guy was off his knees.
Right.
And in an aggressive stance, to say the least. Okay? So you got all three of those issues are disputed.
Okay.
And are they material facts?
Yes.
They are. They're not immaterial facts. It's not like he was wearing, that they're disputing whether or not he wore a white or a blue t-shirt. That would be an immaterial fact. Okay? So you've got at least three material facts that are disputed. So in a ruling on a motion for summary judgment where there are genuine issues of disputed fact, should the trial court weigh the evidence and draw inferences contrary to the non-movement's competent evidence?
Okay, so that's what I missed. And of course, that is the rule.
What's the rule?
Well, if there are genuine issues of material facts, a moving party cannot be granted a motion for summary judgment and weigh the evidence.
Read it.
Okay. I just said, well, my rule is exactly kind of like what my issue was.
Yeah, so
Yeah.
read the rule of the case now.
I said summary judgment.
Next time you'll get it.
I just said summary judgment may be granted only when the evidence viewed in the light most favorable to the non-moving party established that the movement is entitled to judgment as a matter of.
But that doesn't make any sense in this case. Does it?
So you want me to incorporate that to what you said was the issue?
Why does that not make sense?
It's part of the.
Because that's not the issue. That's a statement of law, but it's not, but it has nothing to do with what the issue is. The issue is weighing evidence, and can the court weigh evidence on a motion for summary judgment?
Okay.
Right? So the court ruled First paragraph, per curiam. You know what per curiam means?
No.
All 9 justices agree.
Okay.
Okay, all 9 justices agree. And they're not gonna even say who wrote this opinion, because it's so apparent that this ruling is correct, that we're all saying that we agree with this, okay? The evidence of the movement is to be believed. The evidence of the non-movement is to be believed. That means the party that's opposing the motion. And all justifiable inferences are to be drawn in his favor. The rationale is genuine disputes are generally resolved by juries in our adversarial system. So in other words, on a motion for summary judgment, the court looks to the non-movement's evidence, okay? And essentially takes the non-movement's evidence as being the evidence. And if that evidence, evidence demonstrates that there's a dispute on a material fact, and it does not warrant judgment against the non-movement, then the motion is denied. Okay? It's only when the evidence that the non-movement puts forth, this is what you read, when the evidence that the non-movement puts forth establishes that judgment should be rendered in favor of the moving party, okay, then the court can grant the motion. But if the non-movement establishes facts which, as it says here, is to be believed and all justifiable inferences to be drawn in its favor, then the motion should be denied. Okay?
Professor, what page is that portion?
The bottom of 592.
Yeah. The court goes on to say, by weighing the evidence and reaching factual inferences contrary to Toland's competent evidence, the court below neglected to adhere to the fundamental principle that at summary judgment stage, reasonable inferences should be drawn in favor of the moving party. The court should have acknowledged and credited Toland's evidence with regard to the lighting, his mother's demeanor, whether he shouted words that were an overt threat, and his positioning during the shooting. The judgment was reversed and remanded. Okay? And you know what the burden of production is? Just what it sounds like. It's the burden of producing evidence. Okay? So on a motion for summary judgment, the burden of production for the claimant is every element of the claim. Make sense? Yeah. The claimant has to prove every element of their claim. If they don't, then they're going to fail. By the same token, for the defendant, the burden of production is all affirmative defenses. If they don't prove each element of their affirmative defenses, then they're going to fail. Now let's look at what happens when the defendant moves for summary judgment, which is, as I said before, the usual case. Daniel, let's look first at Rule 56C, which is on page 443 of the supplement.
Alright. 56C, procedures. 1, supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by A, citing to particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, including those made for purposes of the motion only, admissions, interrogatory answers, or other materials. Or B, showing that the materials cited do not establish the absence or presence of a genuine dispute, or that an adverse party cannot produce admissible evidence to support the facts.
So
2,
you could, as a defendant, say, this is all the stuff that the plaintiff has produced, right? And this is their complaint. This is what they've said in discovery. This is what in written discovery, this is what the witnesses say their witnesses say at deposition, and that doesn't establish their case. They can't prove their case. You can do that. They don't have to, there's no burden on the defendant in that situation to produce its own evidence. It can take the position that plaintiff's evidence is insufficient. Okay? Get it? Okay, let's keep going.
2, objection that a fact is not supported by admissible evidence. A party may object that the materials cited to support or dispute a fact cannot be presented in a form that would be admissible in evidence.
That means that you can make objections to the evidence as part of your motion, and then the court has to rule on it. Okay? Keep going.
3, materials not cited. The court need consider only the cited materials, but it may consider other materials in the record.
And
4, affidavits or declarations. An affidavit or declaration used to support or oppose a motion must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify on the matter stated. Moving on.
no, that's it. Okay. Let's do Celotex.
Can I do that one? I was a little confused on the burden. It should be like a burden.
Okay. If you're confused about it, why do you want to do it?
Because I don't know if I had a good grip on it, and that way I can ask the questions. That way I will understand it.
Well, you can ask questions while we're going along. Just a minute, hold it,
Okay.
just a second.
Yes.
Did you read bias?
Yes.
Did you do bias?
Yes.
Okay, so ask questions in Celotex,
Okay.
all right? And let Daniel do Celotex.
I'm ready.
Celotex is an often cited case. Oft-cited case?
All right, so
Wait, hold it, one thing. You can sit down for a moment. So, you understand what this case is about? In asbestos litigation, one of the primary issues is whether or not the plaintiff was exposed to asbestos. Okay? And usually it's established by both testimony of people, well, go back. Most of the plaintiffs in asbestos cases are working men or women, many of whom were in the military. A lot of the cases come out of naval shipyards. especially where the ships that these guys were working on were older ships, because all the pipes in a naval ship or in any ship were lined with asbestos. Okay. But it could also be guys who were mechanics who were working in auto shops, because brake linings were had asbestos in them, and in other work sites. If it's a mesothelioma case, you see all the ads on TV for mesothelioma. Mesothelioma is a killer, and it's a miserable, horrible death. So those cases are worth a ton of money, even if the plaintiff is alive, because the plaintiff can point to how this guy's going to suffer a horrifying death. Life from discovery to death is usually 2 years. And if you have mesothelioma, only 2 things can cause it. Exposure to asbestos, like in the workplace, or having been to a small village in Africa where they mined asbestos. That's it. Okay? So unless the defense can show that this guy went to that village, what are the chances of that? Slim and none, right? So there's really not much of an issue if it's mesothelioma, it's asbestos. But if it's anything other than mesothelioma, it's usually lung cancer. And what causes lung cancer besides asbestos that you can think of off the top of your head? Smoking.
Carcinogens, yeah.
Smoking. Right? So the defense is always looking to establish that this person was a smoker. Okay? So that's the main issue here is, was this person exposed to asbestos, number 1? And 2, the plaintiff's going to try and establish that he wasn't a smoker. And then it's up to the defense to establish, no, he was a smoker. Okay? So that's what this case is all about. And it's usually established by a combination of workers. There was this one case where some workers testified that asbestos was falling from the ship above like snow. Okay, that would establish exposure. If that's not the case, it's usually not falling from the sky like snow. Then there's usually experts who testify about epidemiology, and that the manufacturer involved did produce asbestos containing products, and the product that this person was working with had asbestos in it. Okay, so that's what this is all about. Okay, there you go, Daniel. By the way, these are big dollar cases. Most of these cases go for close to $1 million or more.
All right, so Catret, is that how you say it? Catret sued a number of asbestos manufacturers, including Celotex Court and District Court, claiming that her husband died from exposure to the manufacturer's asbestos. Celotex filed a motion for summary judgment on the ground that Catret failed to present any evidence showing that her husband was exposed to any of Celotex's products. In objection to the summary judgment, Catret submitted 3 documents. One was a transcript of a deposition of the decedent, a letter from an official of one of the decedent's former employees, and a letter from an insurance company to the respondent's attorney. So all these documents were in support and suggested that the decedent had been exposed to Celotek's products. The district court granted summary judgment because Cotret lacked sufficient evidence. They ruled that they lacked sufficient evidence to show her husband had been exposed to Celotek's asbestos in the District of Columbia or anywhere else. And then the Court of Appeals reversed on the ground that Celotex hadn't offered any evidence to support its motion. So the Supreme Court granted certiorari. So for the issue I have, does a party making a motion for summary judgment need to provide affirmative evidence in the form of affidavits to support its motion? The rule I have is on 584. It says, the court ruled that we find no express or implied requirement in Rule 56 that the moving party support its motion with affidavits or similar materials negating the opponent's claim. The court says that summary judgment is designed to afford the parties a just, speedy, and inexpensive resolution to their controversies. The party seeking summary judgment carries the initial responsibility of informing the court of the reason why the motion should be granted by identifying those parts of the lawsuit lacking a genuine issue of material fact. However, there's no specific requirement under Rule 56 that the movement has to provide affidavits to support its motion. A party making a motion for summary judgment doesn't need to provide affirmative evidence to support its motion. The Court of Appeals incorrectly assumed that the moving party was expressly or impliedly required to provide affidavits or other evidence disproving the adverse party's claim. The summary judgment motion should be used to identify factually insufficient claims or defenses. So while the moving party does not need to present affirmative evidence, the non-moving party is expected to present some form of affirmative evidence to overcome the challenge. So the Court of Appeals.
There you go. That's the key to the case. Say that again.
The non-moving party is expected to present some form of affirmative evidence to overcome the challenge.
And was her evidence sufficient to overcome the challenge?
No.
Why?
That I don't think I have in my brief.
That, you got it? It took a while.
Yeah.
That's what the case is all about. I've got here issue. Does Rule 56C mandate entry of summary judgment after adequate time for discovery against the party who fails to make a showing sufficient to establish the existence of an element essential to that party's case? Answer, where a party fails to make a showing sufficient to establish an element essential to that party's case, there can be no genuine issue of material fact, and summary judgment must be granted. So what was it that Celotex was saying she failed to do?
Show sufficient,
It's about exposure.
show sufficient evidence that he was exposed to their products, their asbestos
Well,
products.
specifically, didn't they say they failed to identify any witnesses that he was exposed?
Oh, yeah. Yeah.
That's it.
Mhm.
What was in these three documents that she produced? What were the three documents?
It was a transcript of a deposition of her husband, a letter from an official, letter from an official of one of the decedent's former employees,
What did it say?
whom the petitioner planned to call as a trial witness. I don't think it says what it says.
It didn't say.
No. And a letter from the insurance company to the respondent's attorney.
none of those established exposure, right?
Yeah.
So there.
Hmm?
It says that all these letters were stating that he was exposed to asbestos products in Chicago, but they didn't actually say Celotex, but these
Just
letters.
exposed to asbestos,
Yeah.
but
that's
not
all it
to,
is.
not to Celotex products.
And the other side argued that was hearsay anyways, but it didn't say what the content of the.
It has to be, it's not enough to be exposed to asbestos. You have to demonstrate that he was exposed to your client, to the defendant's
Yeah.
product. Okay? So, for example, one of the things that my law firm did was defend the evil empire, asbestos manufacturing. And I wound up in this trial of a guy who worked in the naval shipyards. And there were two products that were two defendant corporations that we were defending in this case. One of them produced a flexible ring that was inserted between the pipes when they would put pipes together. Okay, and so they had to establish that one, the flexible rings were in that ship, and that their client worked where the pipes were located. Okay, that did it. That was sufficient. All right. The plaintiff can't say I was exposed to asbestos, or the deceased. He doesn't know. And he certainly doesn't know whose product he was exposed to. But so in these asbestos cases, they'll establish that each defendant's product was at least there, okay? And that the guy worked there. That's sufficient to establish exposure. But they didn't do that. So, letters saying that the guy was exposed to asbestos isn't enough. Got it?
It has to be Celotex
Yeah.
asbestos.
Okay?
Yeah.
Close, but no cigar. Yeah, their position was they didn't produce any witnesses that he was exposed to Celotex stuff. Okay, now. You said you had questions about Celotex.
Yeah, I wanted to know, although it was kind of answered when we made Daniel reread that, the burden is on the non-moving party to show that there is a genuine issue of material fact.
Right.
I just want to know where that burden was in, once you reread that.
Well, yeah, and the burden's on the plaintiff in this case to show that there's exposure. Right? Celotex is taking the position she can't demonstrate exposure to our product. So then what's her burden?
Just to prove that they were exposed to it.
You don't have to prove
Well, not
it.
prove it,
You
but
have to
sufficient.
produce evidence
Yeah.
to support
The dispute.
the content, to support the fact that he was exposed to Celotex asbestos. Okay, she does that, then you've got a triable issue of fact for a jury, and now the jury has to decide, maybe Celotex comes back with expert testimony that the amount of asbestos that contained in the product that was present where this guy worked was so infinitesimally small that it couldn't produce lung cancer. Okay? And then, of course, plaintiff's gonna come back with their expert who says, of course it could. This is true. There'll be experts who have testified that one asbestos fiber can cause lung cancer. Okay? And it does, by the way, the symptoms don't arise for about 20 years. Okay, so that's why you're still seeing cases. They haven't been making anything with asbestos in it since the 70s. Well, but there's still old cars running around, and there's still some ships with asbestos. You know, everybody's trying to remove asbestos, but not everybody has done it. So you can, if you're exposed to it, if you're in a house where you think that was built prior to 1970, and it hasn't had, and it has, for example, if it has a furnace with pipes, okay, or if it's forced air, I'll have asbestos in it if it was built prior to 1970. You got to get that stuff out of there, and you can't do it yourself. You got to get these guys in the white suits. Okay, that stuff's dangerous. Okay. So why don't you do bias?
Yeah.
This is another example of what happens on a motion for summary judgment and burden of production.
Okay, so Bias was a star basketball player at the University of Maryland. He entered into a representation agreement with Advantage International, the defendant, and was later drafted in the first round by the Boston Celtics on June 17, 1986. 2 days after the draft, he died of a cocaine overdose. Bias's estate sued the defendants, alleging breach of contract by not obtaining a $1 million life insurance policy on Bias's life.
And they were supposed to do that in their contract.
And misrepresenting that they had obtained a policy and thus preventing them from recovering and securing the necessary insurance coverage. The district court granted the defendant's motion for summary judgment because the evidence showed that no insurance company would have insured Bias because of his past cocaine use, and Bias's estate appealed.
What was the evidence? That's what the case is all about.
Yeah, I have that in my analysis. So, do I read the issue first? So I have, did the estate carry its burden on summary judgment by asserting specific facts to demonstrate a genuine issue for trial? And then I have the rule on 594.
What's the evidence that the bias parents produced?
I had two eyewitnesses, who stated that that was the defendants. They said that they testified and the basketball coach testified, as well as drug test results, that none of that suggested that he was a cocaine or drug user.
That's not the evidence.
That's the evidence.
What did the court base its opinion on?
That they didn't have sufficient evidence to show that any insurance company would give him life insurance regardless of asking him.
So that was the defense. I'm sorry, that wouldn't be a defense. That was the defense claimed that this guy was a cocaine user,
Yes.
and that no insurance company would insure this guy
Yes.
because if anyone gave this guy a physical exam, they would determine that he was a cocaine user,
Yes.
right?
Mhm.
So that's the basis for their defense, is that no insurance company would insure this guy.
Mhm.
Therefore, even though we didn't buy him insurance, it doesn't make any difference. There's no causation because nobody would buy this guy. Nobody would provide insurance for this guy. All right? So the burden now shifts to the plaintiff to establish that an insurance company, one insurance company, that's all you gotta do is produce out of thousands of insurance companies in the United States. Insurance company, Podunk Insurance Company
Mhm.
would have issued this guy a policy.
Mhm.
Okay, they beat the motion.
Mhm.
So what was their evidence?
Well, their evidence was,
What was the plaintiff's evidence?
the general statements from the parents and the basketball coach and the drug test that said that he wasn't a drug user. However, the court said that that wasn't sufficient to prove that an insurance company would give him.
That has nothing to do with it.
Exactly, that's what the court said.
No, they did. The defendant produced evidence that every insurance company inquires about prior drug use.
Oh,
Okay,
yeah, they offered evidence that the insurance companies did not inquire about the drug use at certain stages of the process.
right.
So that was the evidence they offered, but they didn't come with specific facts to demonstrate that some insurance company would have insured bias.
There you
without
are.
requiring.
That's it. That's it. Okay,
Mhm.
that's what they failed to do. And what did the district court do?
So they affirmed it, saying they failed to meet their burden.
And they failed to meet, and the plaintiff failed to meet their burden.
Yes.
Yeah. Okay, so what's the issue?
The issue I had was, did the plaintiffs carry the burden on summary judgment by asserting specific facts to demonstrate a genuine issue for trial? And they did not.
What rule did you get?
I got on 594, once the moving party has carried its burden, the responsibility then shifts to the non-moving party to show that there is in fact a genuine issue of material fact.
That's it. You got it. Okay? So how did it apply it?
They applied it by saying that once the defendants showed that there was no genuine issue, then plaintiffs had the burden to prove that an insurance company would, and they said that the evidence that they had put forward wasn't sufficient to prove that any insurance policy would have,
Any
Insured
insurance
him.
company?
insurance company would have insured him.
Yeah, I've got, since plaintiff did not name a single company that did not inquire about drug use before issuing a jumbo loan, it failed to do more than show that there was some metaphysical doubt as to the material facts. There was no genuine issue of material fact. Metaphysical doubt ain't enough. Okay? All right. So those are two good examples of motions for summary judgment and the burden of production. Okay? Again, for plaintiff to move for summary judgment is rare. As I said before, the effect of a summary judgment is it becomes a final judgment. And because it's a final judgment, the granting of a motion for summary judgment is subject to appeal. So if the defendant makes a motion for summary judgment and it's granted, it's appealable, and that's why we got these cases. Okay? What about a denial of a motion for summary judgment? You think that's appealable?
What do you, the denial just mean that's going forward?
Huh?
I'm saying like, wouldn't a denial of a summary judgment just maybe go to court, so they'll be going to trial either way?
If the motion is denied,
Mhm.
it'll go to court.
Mhm.
That's right, it's gonna go to a jury. Unless the parties waive jury and it goes to a judge. But whoever, the party who filed the motion for summary judgment that was denied isn't gonna waive jury in front of that judge. So it's gonna go to a jury, right? So you think it's not appealable? What did you just say?
Yeah.
Take a stance.
Yeah.
Yeah. Anybody disagree?
I think it's appealable.
Not. Except civil rights cases,
Oh.
okay? Civil rights cases are appealable. Why? Because the courts favor the government. And they give the government a crack at the courts of appeal. All right? And remember that case I told you about where I was representing that guy who up in Amador County? And they seized all of his, every stick of paper in his office at home and all the guns. And the Superior Court up there threw out all of the searches because the search warrants weren't any good. Well, so the defendants, 5 different law firms, all filed appeals after their motions for summary judgment were denied. Okay? And that took 2 years. Then the Ninth Circuit, I got to argue in front of the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals ruled mostly in our favor. It granted partial summary adjudication on a claim, but there were like 10 claims. Okay. And I think we had like 10 different defendants, every cop that was there, and DAs, and anybody that had touched this thing. And they dismissed it as to a couple of the cops. And I think the DA from that county. But not the DA who was in charge of the case. That makes no difference as long as they're in. You know. So, but at any rate, so then it came back on the return from the motions from summary judgment. They filed another round of some motions for summary judgment on other issues that were left open by the Ninth Circuit. So then we had to oppose those motions for summary judgment. They were denied, and it went back to the Court of Appeals again. So ultimately, these guys bought 5 years on appeal. Okay? That's not unusual. That's what the defendants do in civil rights cases, especially if it's a good case. They don't want it to get to a jury, and they're hoping that by the time 5 or 7 years go by, that the plaintiff will have left the country, died. Well, in our case, they were hoping that my client would die because at the time that they filed the case, we filed the case, he was 65 and he had a heart condition. He's still alive. Anyway, so that's what happens. Okay? And then when you get close to trial, and they call up and they say, let's settle this case. So, we've now gone through motions for summary judgment. What's next?
The trial.
The trial. The best part. the part that most of you will never see. Unless you watch a movie.
It seems like it takes forever to get to the trial.
Well, I was talking to Daniel about this, right? And I said, if you want to get trial experience, you don't go to work for a civil law firm. You apply for a position with the DA's office or the public defender's office. It doesn't matter which. Or in cities where they have a city attorney's office and they go to trial, not Palm Springs. But, you know, like LA has a city attorney's office and they prosecute misdemeanors. And all of those offices, you get jury trial experience. In 2 to 4 years in either the DA's office or the public defender's office, you should have at least 25 trials under your belt. Probably more, okay? Now, you go to a civil law firm. Remember, for those of you who were there and we had this seminar, and there was this really good plaintiff's attorney and he had his son there, and he said his son was in his 7th year and he was going to be trying his first jury trial. Okay, does that tell you something? So you want to go to trial, you want to try cases. First, you got to go to one of the government offices and try some cases. I'll just do a real quick intro and then we'll take a break. I don't have much left, but choosing and challenging judges and due process. The general rule is that the due process clause incorporates the common law rule that a judge must recuse himself when he has a direct, personal, substantial, pecuniary interest in a case. So it's not just an interest, it has to be a substantial and personal interest. Okay? What's a pecuniary interest?
That'd be monetary, money.
Well, it doesn't have to be, it doesn't have to be cash. It could be owning stock in a corporation, right? Or it could be it's about, the lawsuit's about something to do with a building, you own the building. Or you're a partner in the partnership that owns the building. The judge can he hear that case? You'd say no? Yeah, you'd be right. Okay? If you've been following anything in this brouhaha about the attorney general, the guys who've been, appointed as attorney general and how they, whether or not they should recuse themselves, okay? They're talking now about, or they have been talking now about the ethics decision. They have an office of ethics within the attorney general's office on whether or not the attorney general should recuse himself from any cases. Okay, and with respect to the special counsel investigation, Democrats in the Senate and in the House are taking the position that the current nominee should recuse himself from the special prosecutor's investigation because he wrote like a 20-page opinion letter saying that prior to being appointed, saying that he thought that the special counsel's investigation was inappropriate. Okay? So, does writing something like that cause a judge to recuse himself before he becomes involved in the case? We'll go through that after the break, okay, and we'll look at the rule on recusal. But my suspicion is that although nobody that I've seen in the media has pointed out what the rules are that the Attorney General is using for recusal, I would suspect that they're the same as this rule. Okay? Because the rule says what you're supposed to, the basis for recusal. So why change it? It would probably be the same for the head of the Attorney General's office as it would be for a judge. Because the whole idea is to avoid the appearance of bias, even if you're not biased. If it just looks bad, they want to eliminate the possibility of it looking bad. Okay? That's the whole purpose of this. So we'll look at that after the break. And we'll see if they came up with chocolate.
Have fun with chocolate.
You got chocolate? Oh, you
The
got
M&Ms.
M&Ms? I can't eat nuts. Okay, 15.
I know, there's no point. Not that I care, not that it's like too big a deal. It's like, we'll get through it.
What is it like the keys?
What?
What is it like the keys looks good?
It's a nice case.
Okay.
It's a good case. And like this house.
I don't know, I actually like them that it depends on like.
Well, for you,
You get a break? Did you get a break?
I got a break because I read.
I was telling him, his notice, I'm like, I'm sure Claire's gonna get a break tonight. I'm like, yep,
And
here
here
it is.
I was rushing to do all the briefing. I said, Chuck, you should have told me this last week.
I mean, I've done that before, not read cases, and I hate just not being able to follow, even though I don't need to do.
I have to read it over a couple of times. And this
Oh.
time it just took a little too long.
That's fine. We didn't case one that long ago.
No, but I had to read the cases over.
Mm,
Understand.
Yeah.
Oy.
I can't keep up with all the stuff going on at the White House.
With what?
At the White House. Every time I turn around, somebody's,
Oh, it changes daily,
I know,
sometimes within the day.
it's like, what happened? Somebody's arrested or somebody.
But but I think the standard that they probably are using within the Attorney General's office is the same as this rule.
That's so funny.
Which is, let me go back and look at it. I don't think that there's any statute that governs it, so why not just use the rule? And because it sounds like that's what they're doing. They're saying because this guy wrote that letter where he took a position contrary to the investigation, he should recuse himself. And before I read these cases and this part of the chapter, I was wondering, what are they referring to? Why should he do it? Now I know. This has got to be it.
That's not it, okay. Okay, we did it. Right.
Okay. So everybody turn to page 552 of the supplement.
Supplement.
Supplement. This book.
Oh, shoot. Okay.
What?
I said, shoot, I brought this one. I'll bring one next time.
Hi, sir. Okay.
Okay.
Go to federal statutes. You're gonna have to get this book if you didn't get it.
I think I got it. Yeah, I have a blue one at home, yeah.
All right, well, for now, you better, if you don't have this this book, you better get it, because when we go to California, this is what we're using.
I
Okay.
have it.
So, if you go to California federal statutes, which is in that book, and then you go to the statute section, it's 18 USC 455. In this book, that's on page 552. Okay?
Mhm.
And this is the federal rule. This isn't a federal rule like the rules of civil procedure, but this is the statute that governs recusal in federal court. Okay?
Okay.
So the general rule was, before adoption of this, in common law, that a judge should recuse himself when he has a direct personal substantial pecuniary interest. Okay? Now look at this, 455 section A requires recusal in any proceeding in which the judge, justice, or magistrate impartiality might reasonably be questioned. That's much broader. Notice it's might reasonably be questioned. It's not subjective on the part of the judicial officer. It's not whether or not he thinks he might not be impartial. It's whether someone else might reasonably question the judge's impartiality. So the only issue is, does the judge think that the circumstances are such that his impartiality might be questioned by others. Okay? Section sub B we'll look at in a little while after we do Caperton versus AT Massey Coal Company. That subsection lists a whole bunch of circumstances that require recusal. And then the issue becomes interpreting the facts and seeing whether the facts come within the statute, okay? So before we go there, let's just look at, in general, the test for whether or not a judge's impartiality might be questioned. And that is found in Caperton versus AT Massey Coal Company, the U.S. Supreme Court case in 2009. Okay. Yes, can you do it?
Yep, I'll do it. Yeah, I'll do it. I got it.
Okay.
Okay. So, in October of 1998, Hugh Caperton filed a lawsuit against Massey, which is a coal company, for tortious interference, fraudulent misrepresentation, and fraudulent concealment. A state trial court in West Virginia ruled against Massey and found it liable for $50 million in damages. So the Supreme Court of Appeals of West Virginia granted review. However, before the hearing, Caperton motioned for Justice Brent Benjamin to recuse himself because Benjamin had, Massey's CEO, Don Blankenship, had donated $3 million to Benjamin's campaign to win a seat on the Supreme Court of Appeals.
Whoa, 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 whoa. Go back a little bit.
Okay.
What did Blankenship do?
He donated money. He donated $3 million to Benjamin's campaign to win a seat on the Supreme Court of Appeals.
While the case was going to be pending? While the case was pending?
Right.
Okay. So the Supreme Court hadn't heard the case, and Benjamin's running for Supreme Court to fill a vacancy.
Right.
Benjamin contributed more than $3 million. Was that a substantial amount?
It was, it said, well, it said he donated $2.5 million, and it goes on to describe the other, donations that he made, but I thought it totaled about $3 million.
Well, it said, didn't the court say that it was more than all of Benjamin's other supporters combined? And 3 times that of Benjamin's own committee.
Yeah, he found some kind of a loophole, I think, through the committee
What?
or something.
What?
I think he found like a sweet spot in the committee to donate, and he did.
Well, wouldn't you say that $3 million, which is more than anybody, than all the other donors combined, and 3 times that of Benjamin's own campaign committee?
Yeah.
That's a substantial amount?
That is a substantial amount, yes.
I mean, do you think that would get Benjamin's attention?
You would think. But no.
Okay, so Benjamin won the election.
Benjamin wins the election, and
then Blankenship filed an appeal.
right, he files an appeal, and so it does go before the West Virginia Supreme Court of Appeals. And Benjamin, in a 3-2 decision, Benjamin votes to reverse the trial court in order to dismiss the case.
Well, what happened when Benjamin won, defendant then filed an appeal? What did the plaintiff do after Benjamin filed an appeal?
He, I think there was a rehearing. He filed. So when the
What
West
would
Virginia,
you do if you were the defendant if you were the plaintiff in this case, and Benjamin was sitting in the Supreme Court, and Blankenship now files an appeal before that court, would you file a motion?
yeah, he filed to recuse him. He wanted a hearing to have Benjamin recuse himself from the case.
Right, and what did Benjamin do?
I said, well, it failed again. He didn't recuse himself.
What?
He did not recuse himself.
That's right. And what did he do after he denied the recusal motion and refused to recuse himself?
I believe he didn't he say there was an improper venue in West Virginia, and then he tried to get it moved to Virginia?
No. He cast the deciding vote.
Yeah.
That reversed the $50 million verdict against Blankenship's company.
Right.
So what's
then
the
the
issue?
court granted.
What's the issue?
Then they granted him the hearing, but again he denied his motion to recuse himself.
What's
so
the
then they
issue?
took it to. The issue is, did Brent Benjamin's failure to recuse himself from participation in the case where one of the parties donated $3 million to his election campaign violate the due process clause of the 14th Amendment?
Okay, and what did the Supreme Court?
The Supreme Court ruled. They said yes, indeed. They held that the due process required that Justice Benjamin recuse himself, and they said that. Where was that? Hold on for 1 second. There was a great quote from Justice Kennedy. Said the appearance of conflict of interest was so extreme that Benjamin's failure to recuse himself constituted a threat to the plaintiff's constitutional right to due process under the 14th Amendment.
Did the court apply a test for
Yeah, they said that the risk of bias exists when a judge has a direct, personal, substantial, and pecuniary interest, as did Justice Benjamin.
Well, that's the general rule.
Oh, okay.
What's the test that they use to determine whether or not that was the case?
I'm not sure.
Okay. Kennedy wrote, where the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable, due process requires recusal. So the test is the probability of actual bias. Okay? The court goes on in this case to say there is a risk of actual bias when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending. And in this, and with respect to Blankenship, it says Blankenship's significant disproportionate influence, coupled with the temporal relationship between the election and the pending case, meaning this all happened at about the same time he was helping this guy out in his election at about the same time that he filed his appeal, offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. On these extreme facts, the probability of actual bias rises to an unconstitutional level. So they found these facts to be extreme. Okay? What is disturbing to me is if you look at the dissent, Roberts, Scalia, Thomas, and Alito all said that they didn't like the probability of actual bias test because it can't be defined in any limited way. So would they have allowed this judge to sit? I don't know. I mean, if these extreme facts don't warrant recusal, I don't know what does.
Yeah.
Anybody disagree?
No, I don't know why. I was surprised too that.
I don't know. I don't know what they're thinking, but at any rate, I guess maybe they're saying we should have a better test. But the test is probability of bias, whatever that means. It's probable, more likely than, probable means more likely than not, that the judge would be biased. Okay, but just remember that, probability of bias test. Okay, let's go to pages 606 and 607. And see how this works out. So we don't want Clara just sitting there doing nothing. Why don't you read paragraph 1?
On the notes and problems?
Yeah.
Okay. In most federal and state courts, there is more than one judge. And so the clerk's office will randomly assign each case to a judge unless the case is connected with pending action, in which case it will go to the judge already managing the related matter. Student leads a demonstration protesting the university's alleged failure to address sexual harassment on campus. Invoking diversity jurisdiction, university sues student alleging that she unlawfully destroyed university property in the course of the demonstration. Suppose that the case of university versus student is assigned to Judge Michael Lopez. The statute calls for the judge to recuse himself when he realizes a ground for recusal exists or when one is brought to his attention by motion. Read 455 and I'll analyze its application to the following 3 scenarios.
Okay, so let's read 455.
That's where we did the disqualification of justice, judge, or magistrate.
Yeah.
So, well, A, any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. B, he shall also disqualify himself in the following circumstances. 1, where he has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary fact concerning the proceeding. Where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it.
Okay, let's go over to 2.
2, where he has served in governmental employment and in such capacity participated as counsel, advisor, or a material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case in controversy.
Okay, now read A.
Okay, so A, when he was in private practice, Lopez represented the university in 2 lawsuits alleging medical malpractice in its hospital. So recusal,
Read.
and that was B2,
Okay,
or 55 B2.
so what do you guys say?
It's arguable. Because the matters aren't really related. One's for demonstration or protesting in a university.
It's not the same matter.
Not the same matter, yeah.
It's not, the word is concerning the proceeding, which is this, meaning the same matter, okay? So the answer is no. It's not arguable. It doesn't fit the statute, does it? If it was the same matter, yes, but it's not.
Okay,
Just because he was a lawyer for the university, I mean, he could have done something, he could have been in, you know, a department that didn't even involve litigation. We don't know, but it wasn't involved in the same matter.
okay.
It has to be the same matter.
I have a
Okay.
question. This says for any justice, judge, or magistrate of the United States. So are these only for federal judges because these are the federal rules?
This is a federal rule.
Okay.
Yes, that is not state, California has its own rules. Okay? Each state has their own rules. This is just governing federal court. Everything in this book is federal,
I would imagine they'd be pretty similar though.
but they're not as specific in California yet. So B. Oh, here's one for you. So I get assigned this case in my law firm. Okay, one of the partners was appointed to be a judge. So he had a case that was on fire that had to go to trial within 30 days. And the managing partner came to me and said, you know, it's a really complicated case. Can you know, put everything aside and get ready for this case? You have basically a month to do it. And I said, sure. I didn't know what was involved. They said, you know, well, it's in Orange County. You'll have to go down to the office and, you know, talk to the managing partner down in Santa Ana. He'll bring you up to speed. So I go down to Santa Ana and he said, oh, well, you're gonna have to go to the war room. You know what a war room is? When you're in trial, you try to create a room called the war room where you have all the, you know, books with exhibits and everything that you're going to use in trial. And so I said, fine. So we go into the war room and it wasn't a room this big, but it was like a room about the size of the kitchen.
maybe a little bit bigger, more like the size of where the office is, okay? And it had on every wall, bookcases filled with exhibit books. Okay, and so I was supposed to absorb all of this stuff in a month. And in the process, I find out that the judge and a plaintiff's attorney is a very well-known, very successful, highly regarded plaintiff's attorney, who has a Hispanic first name and middle name, although his last name is not. But he listed in all of his, on his letterhead, everything is the two Hispanic names and then his last name. And the judge also was Hispanic, which didn't mean much to me until somebody told me that at that time, this was 20 years ago, maybe more, maybe 30 years ago, I can't remember, that they had a Hispanic Lawyers Association in Santa Ana, and that they were both members of it. Well, that didn't really bother me too much until I found out that there were 7 lawyers in this whole association. So, do you think somebody should ask the judge to recuse himself? Guess what? They didn't. So I'm stuck with this guy. And I gotta tell you, that judge ruled against me on everything. It was in terms of getting bad rulings, the worst case I've ever tried. Huh? I won, but I think the jury, amongst other things, I think the jury could see how unfair the judge was being. They wouldn't rule in my favor just because he was being unfair, but I mean, it was a joke. At one point, and he didn't like me because I was from LA, and he kept making remarks about LA lawyers and stuff like that, and so I had to drive. Either I had to I had to take out a hotel room, or I had to drive there every morning. So I elected to drive there every morning, and I was never late. And one morning I ran into hellacious traffic, and I was like 5 minutes late. And the judge has the jury sitting in the box waiting for me. And he's looking, really mad and angry. And he says, "Mr. Moyer, get into chambers." And we go into chambers, and he says, I'm gonna sanction you for being late. And I said, okay. I'm sorry, I beg your pardon. Terrible traffic, but okay. You're right, I'm late. I'll accept whatever the sanction is. He said, you have to buy the jury donuts and have them here tomorrow morning. Donuts for all of the jurors. I said, okay. So I bought, and I think I bought I'm senior moment. What are those really good donuts? We're getting them. Yeah, I got Tasty Cream. Yeah, I bought the Tasty Cream donuts. And they saw me bringing the donuts in that morning, and they got their donuts. And like the next day, I'm going up the elevator, and there's a bunch of jurors in there, and I'm supposed to you know, you're not supposed to talk to the jurors and they're not supposed to talk to you. And so all the jurors are sitting there as we're going up the elevator and say, boy, those donuts were really good. That was really nice of that lawyer to bring the donuts. But that's an example of why we have these rules. That guy should have recused himself. He should never have taken the case in the first place. He should have said, I know so-and-so, we're in the same organization, blah, 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 blah. At least reveal it, right? And let the other side have the option of saying, I think you should recuse yourself. You don't have to have the motion. You can just, you know, yes, Your Honor. And there was another one where it was in Santa Monica, and when I became a partner in the firm, it was in part because I had just been hired out of the public defender's office. So, you know, usually they're not going to make somebody a partner right away. But 5 partners left, and there was a big dispute over how they were going to split up the money and the usual stuff. And so somebody filed a lawsuit. I don't remember who filed the lawsuit, but it was probably the guys who left because they didn't like what the partnership intended on giving them as their buyout. And it went to a judge in Santa Monica who was my best friend. And he called everybody into chambers. I had nothing to do with it because I wasn't a partner at the time that this all occurred, and I didn't have a stake in it. Okay? And everybody liked this guy. He's the best judge in Santa Monica, probably one of the best judges in the county. And he called everybody in the chambers. He said, you guys, I just want to tell you that one of your partners, Steve Moyer, is my best friend. In fact, we just got back from a trip to Africa together. Okay? And you know, if you want me to recuse myself, I will. And everybody said, no. You know, Moyer doesn't have anything to do with this. This is a fight between us, and he wasn't even a partner at the time. And whatever the money involved in this is, he's not coming out of his pocket. And he said, well, okay, I want to think about it. And he called me that night and he said, this is what's going on. Is that true that you're not involved and it's not going to affect your pocket? Right? And I said, yeah, I don't have anything to do with this. I don't have a dog in this fight. Then he said, okay, I'll think about it. And they came back the next day and he said, I don't care, I'm recusing myself. Okay? Because in his view, it would look like he had a bias. And that was the right thing to do. Even though they would waive it, he didn't want to, I don't want anything to do with this. Because somebody, if whoever I rule for, the other side may not like it. So that's how this stuff comes up. So we did A. Daniel, why don't you do B?
Lopez's daughter, a student at the university, was involved in a demonstration that led to the suit and appears on a party witness list. Recusal?
You gotta look at B1 and B4. So we've already read B1. That's the impartiality might reasonably be questioned. And what about B4? Why don't we go to B4?
He or his spouse or a person within the third degree of relationship to either of them or the spouse of such a person, 1, is a party to the proceeding or an officer, director, or trustee of a party. 2, is acting as a lawyer in the proceeding. 3 is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. 4 is to the judge's knowledge likely to be a material witness in the proceeding.
What do you think?
Well, if his daughter would be a third degree relationship, right, of somebody that's involved in the suit. So yeah, he has to recuse himself.
Well, she's a witness. So it's at least 4, isn't it? Four,
Yeah. A material.
4, little 4. Yeah, his daughter's a material witness. Well, anyway, she's listed as being a witness.
A witness, we don't know
Yeah,
if she's a
he's got to
material.
recuse himself. Okay?
Mhm.
All right. Isabel.
Before his appointment as a federal judge, Judge Lopez served on the state bench, a position to which he was elected. During one of his state electoral campaigns, he distributed pamphlets calling for tough enforcement of the laws to remind young people that they have obligations as well as rights. A statement that some in the student community interpreted as calling for special severity against students. Recusal, section 455A. 455A, any justice, judge, or magistrate of the United States shall disqualify himself in, in any proceeding in which his impartiality might reasonably be questioned. Well, here, it was already kind of interpreted by some people that he had a bias against young people, so I would think he should recuse himself because his impartiality might be reasonably questioned.
Yeah. Probability of bias, right?
Mm-hmm.
Doesn't have to, I mean, he doesn't have to be biased. The issue is not, is he biased? It's, does it appear as though he might be biased? Or that he's probably biased? Or that there's a probability that he's biased? Okay. Brian, 2.
Suppose you represent a small business owner, a local franchisee of a national firm, in a contract claim where you have drawn one of the 2 following judges. The question is whether either judge must recuse herself from the case under a state statute identical to section 455. Judge Hott. His name strikes dread in lawyers' hearts. Is intemperate, abusive to lawyers, not given to reading briefs or listening to oral argument, and thought not to have studied law deeply either during or after law school. Lawyers with whom we practice report that Judge Hott appears to issue rulings almost randomly. You have good grounds for a recusal motion.
Based on the statute.
I don't see a section that would fall under the facts for any of these.
Well,
well, let's see. So going back to A, it says any justice, judge, or magistrate of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned.
what's that got to do with,
She doesn't seem.
what
to
that
show-
have to do with being an asshole?
Yeah, I was gonna say, it doesn't seem to say anything about any impartiality just because she's like this to all lawyers.
He's just a jerk.
Yeah.
He's not, he treats people badly, he's ill prepared, he's a lousy judge. That's not a basis.
Right, so there's no probability.
No,
So no.
but caveat, that's in federal court. In California, we have a statute that permits either side to file one affidavit of prejudice. Okay? But it can be based on exactly these grounds, that you heard he's a lousy judge and you don't want. It's really not an affidavit of prejudice at all, but that's what we call it, okay? Each side gets one. That's it, okay? So the good news is you can't get rid of a judge like that. In practice, however, no one could prove this in the day, and I don't know what they're doing in LA now, but if you had a case in downtown Los Angeles in the civil courthouse and you affidavitted one of the bad judges who everybody knew was a really bad judge, guess where it got sent?
To the judge?
Huh?
To the judge?
No, it can't. You just affidavitted him.
Oh, was
Or
it
her.
like the journal? Like the
No,
journal?
they reassign it to one of the other worst judges.
Oh.
Oh, no.
Now, we couldn't prove that that was happening, but it was happening.
That was punishment.
Well, no, what they were trying to do was prevent people from filing affidavits because, you know, they didn't want to do that. They wanted to keep all of this particular judge who was getting all these affidavits was just like described here, and everybody was affidavitting them, and then they had an empty courtroom. Yeah.
Do affidavits happen before or after the trial?
Oh, you have to do it in California, I believe it's, you had 3 days.
Mhm.
But I could be wrong on that. I have to go back and look at the statute, but it's a very brief period of time in which to file the affidavit. Okay? On the other hand, in Santa Monica, there was this judge who was like this and everybody knew it. And even though everybody said that, I was assigned to his court and everybody was telling me I should affidavit him. Okay, and I said, I'm not gonna do that unless I go to trial in front of him and he treats me that way. How do I know he's that bad? Give the guy a chance, right? So I go to trial in front of him and that's what he was horrible. Ruled against me on everything. He was awful. And so the next day, in a lot of these courts, the satellite courts, they have a master calendar court, and that master calendar assigns stuff to all the other judges. So I walked in with 100 pre-signed affidavits of prejudice on this judge. And I dropped them off with the clerk and I said, have a good day. And about a day or two later, the presiding judge called me and the guy who is the supervisor for the public defender's office into his chambers with the supervising DA. And he said, so I see that you filed 100 affidavits on Judge X. And I said, yeah, I just had a trial with him. The worst trial I've ever had. Everybody told me I should affidavit him beforehand, but I gave him a chance. And he said, yeah, we know. He said, how about Judge Fitz? Would you take Judge Fitz? And Fitz was downtown, and he was known to be the best judge in the county. And I said, I looked at my boss, and he looked at me like, and I said, hell yes. And he looked over at the presiding DA, and Fitz had been a DA.
he argued the Manson case. Okay, yeah, he was a heavy hitter. And the head DA said, hell yes. Okay, so that's how it works. Okay. But the reason I told you about the other thing is that if the guy is really known to be terrible and the court has nowhere to send this guy, and they don't want him to be sitting around with nothing in his courtroom, then you risk the chance of getting somebody else that's just as bad. So he really has to be bad before you affidavit somebody. Okay?
May I ask a question?
Yeah.
So if there are maybe a handful of judges who are really bad and everybody wants to affidavit them, I mean, is it potentially possible that they would not have any work to do, wouldn't be able to preside over any trials? So
What you do is you have a pre-signed and dated affidavit in your briefcase. Okay? And the only thing that isn't there is the name of the judge. All right? And if you get one of those judges, you should have already done your homework to find out who should I not take. And it's pretty easy to find out. I mean, what you'll see is you'll start getting emails from other lawyers, and they'll say, you know, I got a case that I'm going to trial on Riverside. Is there anybody who I shouldn't take? Okay, and you'll get back some emails, and if it starts looking like there's a theme here, you know, that everybody's saying don't take Judge Black, right? You may want to have some further communications with the lawyers and say why. If they don't say why, you know, why shouldn't I take this person? And then you'll find out. And you'll probably have a list of, there's not that many judges in the courthouses out here. So, you know, you may have a list of 2 or 3 judges that you shouldn't take. And then there are other issues like you have a case that you're suing the city of Riverside, for example. And it turns out that Judge White was a city attorney for the city of Riverside, and they were that judge was in the department or unit of the city attorney's office that defended the city of Riverside in all its lawsuits. You might not want that person. Okay? That doesn't amount to a recusal. If you file a recusal motion and the case that you're handling was not a case that person had been involved in, did they have to recuse themselves? We just went through that. No. So you may want to use your affidavit on that, judge. Or think about it. I would. I mean, I'd think about it. I want to find out more about that judge and how they rule in cases against the city. If it turns out that every case that comes to them on the city, they've ruled in favor of the city, I'd drop an affidavit on that judge in a heartbeat. If it turns out they've been fair, I wouldn't. Okay. So where do we leave off? Wow. Heartbeat? No, we're on 2. So we can't affidavit Judge Hott. So, Trish, tell us about Judge Wise.
Judge Wise, well, he's very well liked by lawyers. He listens carefully, even to ill-prepared arguments. He rules promptly, and even the losers concede, usually correctly. As required by Rule 7.1, you have filed a disclosure statement indicating that 45% of your client is owned by Franchisor Corp. Judge Wise indicates that she owns 10 shares of Franchisor Corp. Both you and your adversary would be delighted to keep Judge Wise on the case. Can you? Analytically, that question has 2 points. First, locate the portion of 455 that says she has a problem. Well, she has a pecuniary interest if she owns shares of the franchise. So that seems to be the problem.
Well, wait a minute.
And-
So, wait, what part is that? That's B3, right?
I thought that was B.
Wait a minute.
See,
Yeah.
Yeah, has a financial interest
That's D4.
that could be substantially affected by the outcome.
I think it's. I must have again, my book was probably different than yours
Well,
for some
okay,
reason.
that's B3. Okay,
Okay.
so what's
So then the second.
that's the first part. That's B3. So that's the part that indicates you might have a problem. Okay.
Right.
So
Isn't it B4?
B4.
That's 3.
I'm sorry, B4.
Okay.
No, B3. B3.
Okay, sorry.
B3. She owns a couple of shares.
Yeah, she only owns 10 shares. I don't think that would be a problem. It depends on how big the company.
Oh, it doesn't say how many, it doesn't say that you have a substantial interest. It just
Right.
says you have a financial interest. Okay? So now, then it says to go to second, read 455E. Does it provide a way for parties to allow Judge Wise to sit? Look at E. Next page. Read E out loud.
Okay. So E says, no justice, judge, or magistrate judge shall accept from the parties to the proceedings a waiver of any ground for disqualification enumerated in subsection B, where the ground for disqualification arises only under subsection A. Waiver may be accepted provided it's preceded by a full disclosure on the record of the basis for disqualification.
But this is B. You can waive what this subsection says is if it falls under A and none of the circumstances in B apply,
Uh-huh.
then you can waive if both parties waive the potential for disqualification and indicate that they're waiving it, then the court can accept the waiver and hear the case, which was like that, what I was telling you about with my friend, and they were both willing to waive whatever the potential for impartiality was, because they thought he would be fair and impartial. Under this, if it's a pecuniary interest and it's, or any of the circumstances in B, then they can't waive it. Okay? Even if it's only 5 shares. Does it? Okay? I suppose, because what B is saying is if it falls within, if it's one of the circumstances within B, you can't waive it. It's not, I suppose you could make an argument that it doesn't fall within B3 because that interest would not
be substantially affected by the outcome. Five shares.
Yeah.
Depending on how much the shares are. And even if they're not a lot though, you still have a financial interest in that if the rulings against the
Yeah,
person that has the shares is gonna affect the dollar amount of the stock, right?
it seems to me that if you've got one of these potential circumstances, you don't wait. Because let's say both parties waive, okay, and then the judge rules against your opponent, then theoretically, I would think that there's an appealable issue here because it says that wasn't waivable. Right?
Right.
And the judge should have been recused. So the whole thing gets reversed. Even though they waived it. Because it wasn't waivable.
Mhm.
Okay, so there you go. Damn. I don't have anything more.
Okay.
You guys did all the reading, right?
Yep.
Okay, next week we finish trial. Then guess what? What do we have after trial?
Appeal.
Appeal. Does anybody have any questions about any of this? Huh?
No.
I think this stuff's pretty straightforward. I'll send you guys a summary of everything that we did last week and this week. Okay? I didn't get to it.
Thank you.
You want to hear about the weekend from hell?
Sure.
Yeah.
Really? So.
Yeah.
So we got this small apartment building in LA. And my youngest son, when we bought it, my eldest son was going to UC Berkeley. And my youngest son was going to UCLA. So he moved in. We kept one, it only has 6 apartments. Okay. So we kept one apartment for ourselves, for the family. And it's a 1-bedroom. And he moved into that apartment. And we figured he'd probably stay for 5 or 10 years, who knew? But not, not longer. And then if the other son needed it, he could move in. So 15 years later,
So
he finally got married, and his now wife didn't want to live there anymore. They bought a house. So picture so he was 21 when he moved in, okay. So figure 37-year-old, been there for 15 years, musician who's lived there for 15 years. What does apartment look like when he moved out? That needed some renovation. One of which was it needed a new bathroom sink and faucets. Don't ask. So we got a new sink and faucet at Home Depot. It's not that expensive. And so Friday came around and it was time to go into LA. We had already bought a bunch of furniture at a consignment stores out here and had it delivered. And we go in to help him move into the apartment. on Saturday. So we stayed there Friday night. And my wife noticed that there was no hot water. And I said, well, you know, he had, son number 2 hadn't been living there for 6 months. Okay. So I figured the pilot had gone out on the water heater. So I get my handyman guy to come over on Saturday, and he said, no, you need a new water heater. I can't do it until Monday. And we're staying over until Monday. So we can't shower for 3 days. And there's no faucets in the bathroom because the tenant downstairs calls me up and says, the water's pouring out of the ceiling in my bathroom. So I'm leaking up in your bathroom. And the handyman looks at that and says, oh, there's a manufacturer's defect in the faucet. So I'll have to get you a new faucet on Monday. So we got no hot water, no faucets in the bathroom. And we had the sewer backup just before I got there, and there are guys out at the side of the building digging up the pipe to replace part of the pipe and put in a clean out. That's going on. Them older son who's going to be moving in says, I can't start the car. The key's stuck in the ignition. So I call up the auto club and they come over and they can't get the key out either. They said, we'll tow it for you to the dealer. So I have to go over to his place that he's moving out of, right? And have them tow his car. So I haven't bathed. I follow the tow truck over. I follow the tow truck over to the Honda dealer in Culver City, and I'm sitting there waiting for the guy to come out and give me the bad news. And there's like a woman sitting over here and another woman sitting over there, and I noticed they both start getting up and moving. Yeah. And he comes out and tells me it's going to be $700. Yeah, well, what can you do? I'm stuck at a dealer. And okay, so anyway, everything finally gets taken care of. It's Monday, and I decide on my way home, everything's done. We got them moved in. Everything looks good. Everything's been fixed. We got hot water. I got the faucet in. They fixed all the stuff in the sewer. I'm going to stop at my favorite cafe and get a nice lunch. And I get home and I notice that I don't have my cell phone. Good news, I called the cafe and they have it. But how's that for a weekend? You like that as a weekend, huh? The joys of property ownership.
Wow.
Yeah, that sucked so bad.
The good comes with the good and the bad comes with the bad.
Yeah, well, place looks great. His apartment looks terrific. All used furniture. You guys got any of the consignment stores out here?
Oh, yeah. All my
It's
furniture.
It's amazing the stuff you can get. We got him a sectional sofa with a sleeper sofa. And never been used.
Wow.
I mean, it was like brand new for $700.
Wow.
It's just amazing. Yeah, these people, they come, like the snowbirds, they come out here, they furnish these places.
Yeah.
and then they decide they don't like it. And they just give the stuff away, basically.
Have a good one. Thank you.
See you next week.
Next week.